All right, so Judge Glanville is out and Judge Whitaker is in, and she is laying down the law. Let's talk about it. My name is Jamahl Kersey, and I'm the principal attorney at Kersey Law. We're a boutique criminal defense firm in San Diego, California, and Judge Glanville is out after the motion to recuse him was granted. And listen, I think most people thought that this was the right thing to do, that he needed to be removed from this case, but most people, while they thought it was the right thing to do, they didn't think it was actually going to happen. There was all kinds of doubts as to whether Judge Krause was going to grant this motion. And listen, I've never heard of a judge being removed this way in the middle of a trial. And, interestingly enough, Judge Krause had said that she didn't really have a problem with the secret meeting and the meeting itself or what was said during that meeting. And I disagree with that. Again, I commented in the video on the topic that I thought it was improper for this meeting to happen without the defense being aware of it, without the defense being present, and also the manner in which Judge Glanville used his weight to essentially persuade or convince Kenneth Copeland to take the stand, even though he had already expressed that he did not wish to testify. But interestingly enough, Judge Krause was more focused on the manner in which Judge Glanville had decided on the motion for recusal. And if you remember, Diamante Kendrick had filed the motion for recusal, and Judge Glanville ended up basically setting forth a timeline. And so when she was writing her ruling, she basically said that a judge in that particular situation, if they're going to make such a record, they need to present the facts in an objective, dispassionate, and non-argumentative way. So in other words, the judge isn't supposed to sound like a lawyer advocating for himself. And that's exactly what it sounded like Judge Glanville was doing, right? So he was just the opposite of what you're supposed to be in terms of objective, dispassionate, and non-argumentative. And so she said that he essentially evaluated and accepted the truth of his own factual allegations. So basically, I'm saying this and I'm accepting it as true basically because I'm saying it. And so based off of that, he just had to go. There was no way around that. And so this is pretty embarrassing, right? I mean, I'm sure none of the judges have ever had to go through something like this in terms of having to be removed from a trial in the middle of the trial. Like I said, I've never heard of this before. And I think Judge Krause was kind of showing the judge some love in saying that, this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But, the key thing was the necessity of preserving the public's confidence in the judicial system. That's what weighed in favor of excluding Judge Glanville from further handling the case. So basically, public perception is everything. You just had a big outcry from the public saying that this was unfair, this isn't right, Judge Glanville's got to go. And so I'm sure that weighed heavily in her decision in deciding to grant the motion. And, we knew this was going to be a really big decision, right? And again, some people doubted whether she could be fair in her evaluation and her analysis, based on her and Glanville working together, or, Judge Glanville being her superior, or even his campaign contributions to her election campaign. And, those are fair concerns, right? But ultimately she did the right thing, and I'm glad she did. And so they had appointed another judge, and then she pretty much immediately recused herself, not wanting any parts of this. Apparently there was an issue with her courtroom deputy related to this case, and there's a possibility that he could end up being a witness. So she was like, hey, I don't even want to let there be a hint of an appearance of impropriety. So she recused herself, and so now we have Judge Paige Reese Whitaker. And it's almost like coming in as a substitute teacher, taking over an unruly class, right? I mean, I like it though. She's got that polite, but I'm running things, I'm gonna keep this thing in line type attitude, and I just dig it. But when you heard her rulings, it really just put a spotlight on how crazy things had gotten under Judge Glanville. And some of these rulings are just things that I've never even heard of and never would even think to hear of in a criminal trial. Like no more eating in court. Like why was that even permitted in the first place, right? So, we're not going to have popcorn and chips or whatever was being eaten. And I know a lot of people made comments on Judge Glanville when he was making his ruling and getting into it with Brian Steele, and he was crunching on something, and you could hear it in the microphone. It just really seemed unprofessional. And so to allow anyone, whether it's the attorneys, the clients, whomever, to be eating during open court with a jury present is just really unprofessional and improper. So she shut that down. She also, interestingly enough, limited the number of outfits that that these defendants are able to wear on a day-to-day basis. So when you're in custody, people are in custody in their jailhouse jumpsuits, right? But for trial, they're permitted to wear clothes, right? So, you can wear a suit or a dress shirt or whatever you want to wear, but typically there's only going to be so many changes of clothing. You might get, 2 or 3 dress shirts, a pair of slacks, and a sport coat, right? And then you have to swap them out. So you don't just get to have a whole closet full of clothes. And apparently there's a bunch of outfits that they had on deck in there. And so the judge is like, hey, I'm not going to put that on my deputies to have to manage a whole wardrobe. So we're going to limit the number of outfits that you guys get while you're in this courtroom. And then one of the real surprising ones was no more headphones in court. And so if you were watching parts of these trials, you would see these guys with, whether they were Beats headphones or what have you, while they're in court, and you're like, what are they listening to, right? And so that was one of the questions that Judge Whitaker had, like, what are these guys listening to while court is in session? And no one was answering her question. I was sitting there curious too, and you could see at some point one of the lawyers is smiling like he got his hands caught in the cookie jar, right? And after a few seconds of silence, one of the lawyers admits that, okay, well, they've been listening to whatever due to boredom, right? And that just kind of blew me away, right? One thing, obviously the prosecution has been dragging this thing out. Apparently there are 200 witnesses that they have in this trial, and there have only been 50 so far, so they have 150 more witnesses. And yeah, if some of the testimony has been going on and on and on, it's been dragging on, some of the same things being repeated, then I could see, potentially how this could be boring. But at the same time, like, your life, or at least your freedom, is on the line, and you're sitting up listening to something else. What could you possibly be listening to? A mixtape, a podcast? So she shut that down, right? In a polite way, she shut down listening to anything during the time that court's in session. And there was actually another lawyer who said, well, I like to try and have my client listen to some of the interviews or things like that, but even that's not really something that you would be doing during the times that court's in session. That's something that you would do. You would go to the jail and, bring the laptop and play the recordings for your client there, not while you're in court. But at the same time, there's just unusual circumstances, right? These guys have been in trial for so long that you maybe try and maximize the time that you can while you're with them. But she's like, no, I really want you to make an effort to play these audio recordings for your clients outside of the presence of the jury. One of the other requests is that the lawyers actually be professional and civil to each other. This is something that I've just never really had to deal with because I always conduct myself professionally. I'm a pleasure to work with. I'm going to advocate hard for my client, but at the same time, there's nothing personal. I've never had anything personal against a prosecutor, and I don't think that a prosecutor should ever have had, anything personal against me. But apparently, there have been some moments where things get heated and people have lacked civility, and there's just no room for that, right? We took an oath and we have a duty to be professional to one another. And so she's just, reining this thing in, right? She's taking control of this courtroom, and that's really what needed to happen. And so again, back to the witnesses issue, the state has 200 witnesses on their list. There's only been 50 so far, meaning there's 150 left. And so she's really trying to cut this thing down. This trial's been going on too long. She has this jury who, they've given up so much of their lives to be a part of this process. And she told them, hey, I want a list of every single witness you have left. Just give me a general idea of what they're going to testify to and which counts it's going to go to, right? Such that she can say, hey, well, you don't need 3 witnesses to tell me the same thing. If this is how the shooting went down, 1 witness is enough, right? So this is going to cut down on the redundancy, and maybe that 150 gets knocked down to 75. A judge has the authority to shut down what's called cumulative testimony. So in other words, if one witness establishes a fact, you don't need to continue to pile on in order to, bolster that fact, right? And so the last thing, it wasn't the last thing that she mentioned, but I think the major issue is the pending mistrial motions, right? So these defense attorneys are moving for a mistrial, and this was the main thing. I mean, you knew that if Judge Glanville got removed from this case, then the defense was going to make a motion for a mistrial. I mean, at the end of the day, the way that Lil Woody was compelled to testify, and Judge Glanville weighing in on it, that was improper. And this is a bail that cannot be unrung. I mean, this guy's been testifying for days and saying all kinds of stuff that if the jury now is somehow supposed to disregard what's been said, that's really impossible to do. She's got a big decision to make on these motions for a mistrial, and so we'll just have to stay tuned. I'm curious as to how she'll rule. Let me know what you think. Do you think she's going to grant the motion for a mistrial and this thing is over, or will she carry this thing on to its end? We'll just have to wait and see. But if you got something out of this, please show me some love. Hit that like button, make sure you subscribe to the channel, and turn on the notifications so you never miss a new video when it drops. As always, I want to thank you so much for watching, and until next time, peace.